This podcast is not a source of legal advice. No two legal cases are the same. Contact an attorney if you require legal assistance.
They get
I'm
people from
interested
different
to learn
walks.
about that because I didn't want to go off on a tangent because it wasn't on topic, but the topic of mental health of law enforcement officers too is and
Yeah.
their ability to interact with people. And I had someone that had a friend or family member that was having a mental health crisis, and they were able to get is it Arise? Is that the program? Able to get someone from one of the wildwoods to go out, and they were able to get this individual in a hospital. I mean, back in the day, the person would have been locked up.
Exactly.
So, yeah, I mean, it's really changed, and it's a really good thing.
It is.
A lot of my clients call the police with help, 10 years ago, 5 years ago. And Gretchen, I know you probably will roll your eyes when I say this, but I used to say to my clients, don't call the police for help. They're going to arrest you because they didn't have the skills at that time.
Yeah. They're being developed now. And I think it's a great thing. I mean, we have that. There's there's barricaded individuals. We have a whole bunch of programs that are out there that are able to assist the police in responding to these kind of situations, and also to assist the people who are in those situations so that you don't make matters much worse than they really are, and you can actually direct things in the appropriate manner.
Yeah.
So I'm very pleased with the way things are working out. I know our prosecutor is just thrilled with this. He is very heavily invested in this, and has been for a long time. So I wanted to at least put out and let you guys know that he's very enthusiastic, and maybe as we go through things, he might be interested in participating as well. So just wanted to let you know.
Who's the judge handling the list?
Judge Waldman.
Judge Waldman.
He's also doing Atlantic County. He was very instrumental in getting us moving on this. I mean, we've been talking about it, but he went and got he spoke to Judge Blee before Judge Blee went up to the AOC, and Judge Blee had said, yeah, let's do it. And they had applied to get us to extend Atlantic's program. This was before the grant even became available. We even knew it existed. So we've been trying to do it.
How often are you having the court?
Right now, it's going to be once a month, staffing and court days on the same date. First day, I think, is February 17th. I don't know how many of the applicants I'm looking at are scheduled for that date yet. But we're getting applications in, and we're going to go forward with it. And if we have to make it 2 separate days a month, 1 day for staffing, 1 day for court, then so be it. We'll deal with it that way. But right now, we're starting off at once.
You're going to need another AP to help you.
Wait, are you volunteering to go back?
Come on,
no, I'm
Meg.
just saying, if I was running the office, I would tell you need another AP.
Well, we're going to see how things go, and I'm going to be involved right now. And, Joanna Visala from our office is going to be involved in things as well. But for startup and to make sure we get grooving, I want to keep my hands in it to make sure we're okay.
Right.
Good.
And I'm just going to shout out Judge Waldman because, this is something that I know he truly believes in.
Very much.
He was in recovery court, so he saw the dual diagnosis issue.
Mm-hmm.
And he's also involved with the Supreme Court Wellness Committee. So I know it's like a genuine, I think that a lot of times judges don't get to be in the courtroom that they want. You're assigned, which, whether you're in criminal or civil or family.
Yeah.
And it's nice to see someone in a courtroom really handling cases that they're passionate about and believe in to really try to provide the treatment for the individuals that are in front of them.
Mm-hmm.
Today on the Mighty Merp podcast, we're taking a deep and necessary look at the intersection of mental health and the criminal justice system, not in just theory, but in practice. I'm honored to be joined by 2 women who are amazing with significant real-world criminal law experience from both sides of the courtroom. Meg McCormick Hoerner. Sorry, Meg. I should be able to pronounce your name. Meg McCormick Hoerner is a certified criminal trial attorney, professor at Wilmington University, and a seasoned criminal practitioner, both as a prosecutor as well as a defense attorney. Her perspective is uniquely informed by having served as a former district attorney of Philadelphia, a former prosecutor in Cape May County, and a former solo criminal defense practitioner in Atlantic County. And today, she also teaches on mental health in the law, giving her a comprehensive view of how these issues play out both in the courtroom and in legal education. I'm also joined by Gretchen Pickering, who is the Deputy First Assistant Prosecutor of the Cape May County Prosecutor's Office. She's been with the office for 12 years and brings extensive experience handling serious criminal matters and shaping prosecutorial responses to cases. She is also the lead in starting a program with the Cape May County Prosecutor's Office based on a grant that was recently received, and will be starting a mental health diversionary program in that court. Today, we'll be discussing the reality of mental health issues faced by defendants who are criminally charged, the purpose and operation of mental health diversionary courts, and really why addressing mental health within the criminal justice system is essential, I would say, to rehabilitation, as well as public safety and reducing recidivism. Welcome, ladies. I'm really excited to have this conversation.
Thank you.
Thanks, Melissa.
So all three of us have been involved as lawyers and in the criminal practice for a long time. So I would want to ask, how do you think that our information and knowledge about mental health and prosecuting and defendants has been shaped over the years? Because where we are today is significantly different than how we address mental health issues previously. Meg, do you want to jump in on that first?
Sure. I mean, I was, as you said, I was a prosecutor for a long time. I was actually down in Cape May County for about 14 years. I had spent about 4 years prior to that in other counties as a prosecutor. So I was a prosecutor for 18 years before going into criminal defense work for about 5 years. You know, one thing I was thinking about as I was preparing for today was just what you said, how the perspective has changed in that time frame. You know, as you mentioned, I'm now teaching a graduate level course for Wilmington University in mental health and the law. And it maybe goes without saying, but when you really break it down, aspects of mental health touch upon every single area of the criminal practice, from before the crime is even committed to why the crime is committed, to how law enforcement react and address individuals that they're interacting with, issues of Miranda, issues of how prosecutors look at it, defense attorneys look at it. And, you know, it's more than just the prosecutor's viewpoint versus the defense attorney's viewpoint. There's this other piece to the puzzle, and that is focusing on, you know, why someone may have committed a crime. You know, certainly our law is set up to excuse certain offenses and justify certain defenses, but it's not a free pass. And unless we understand the why, we can't work on how to reduce and really solve the problem so it doesn't happen again. It's not just a matter of getting the best deal you can get when you're a defense attorney, and it's not just a matter of, you know, getting a conviction if you're a prosecutor. So to answer your question, I'm thrilled to hear that Cape May County now has this grant that they're able to start this program. I'm really excited to hear Gretchen. And Gretchen, nice to see you. I haven't seen you in a while.
Yeah.
To talk about it. I know it's a pilot program in other counties. You know, but I remember, and I don't know if this is the case now, but I remember when someone would be rejected from recovery court due to a dual diagnosis. And what person that has a severe drug dependency does not also have co-occurring mental health issues? I'm not a mental health expert, but you see it everywhere.
Yeah, but that's a really good issue. I know we're already off and running, but 10 years ago, you couldn't have a dual diagnosis. Maybe it's 15, 10 years, 2016, maybe. But I know before 2015, 2014, you couldn't have a dual diagnosis. And it
Right,
really,
and get
it
into
goes,
recovery court. That's
it,
what I remember. So that I think that
yeah,
may have changed now, but
right.
that
But
shows one aspect of how it's changed, and law enforcement's response too, right? In this graduate program that I'm teaching, it's a lot of law enforcement officers who take this master's level program that Wilmington University offers, and just having, and I'm sure Gretchen can speak to this, but the response of law enforcement when interacting with someone who has a mental health issue or mental health crisis, that has changed drastically. So we could talk
mhm,
about that
right,
for a long
right,
time. But the important piece to the puzzle is to recognize that it's more than just about solving the actual case at hand. It's
right. And
about
so,
recognizing it's a bigger issue.
yeah. So, and I asked the question of how far we've come because the example you used about recovery court is a really good example, Meg, which is you couldn't have a dual diagnosis. And for those individuals listening, that meant you couldn't have a drug addiction and a mental health diagnosis and get into recovery court. And it has only been, I would say, in the last 10 years, less than that, maybe even 8 years, that we have acknowledged and recognized that most people that have substance abuse issues usually have a mental health issue. And so it's a change of where we were over 10 years ago or 15 years ago. And I think that's part of the realization that there's a strong connection between people involved in the criminal justice system overall with mental health diagnosis. So, Gretchen, I'm going to ask you really, I'm going to just start with a very easy. If we know the number of cases or percentage wise about the connection between those involved in the criminal justice system and a mental health component.
I don't have statistics on that exactly. I do know that there have been a lot of changes and a pretty strong recognition that mental health issues are issues that have to get dealt with at all levels of the criminal justice system. And for example, we have CIT programs that help teach some of our first responders, police officers, and other people in our offices, teach them how to approach situations where you have someone who might be experiencing a mental health crisis or might have mental health issues. So that recognition is different from what was around 10 years ago. Now, we also have an Arrive program in Cape May County, and I know other counties have that as well, where you have someone with a mental health professional, essentially, and I use that term somewhat loosely, but a mental health professional available to follow up if it is determined that there is something going on or there's a mental health crisis that's happening in connection with some of the phone call to emergency management, say, for example, for response. So those kind of programs have kind of increased based on understanding of the not even sure nexus is the right word. It's almost a spider web, if you will, of the intertwining of the mental health issues and the criminal justice system in a lot of respects. And it ties in with recovery court as well. And I think a lot of it develops from things that people have learned through the years that court has been available to people, and how to approach things differently as a result of what we've learned through those years. So I think that it's all kind of evolved to a sense where the need for this program or for mental health, an understanding of mental health is very important in addressing certain individuals who are involved in the criminal justice system and how it goes forward. And that's what the program is designed to do. No one wants to put someone in jail who's suffering from a mental health episode. So I think the goal is to try and get people involved who are having those situations into some kind of treatment and away from the criminal justice system, which has a more black and white view of things.
Right. So there are other states that have pretty robust mental health diversionary programs
Mhm.
already. I know New York does, and I've had clients participate in that successfully. I know New Jersey has tried to or has had pilot programs, but it's not in all the counties. So Cape May is establishing a mental health diversionary program at this time. Gretchen, could you talk about how I guess, the impetus of that or how that came to fruition?
Sure. As you did mention that there was a pilot program in place. It came through the AOC. That was several years ago. I think there were 4 counties that got grants through the AOC to start a pilot program. I believe Camden was one, Middlesex. I'm not sure of all of them. And this is not part of that program. But what happened, I think, in the course of things, Atlantic County, and there's, I guess, a general recognition of the need to move in a direction to address mental health issues in the courtrooms that couldn't be addressed through the VDP program, the Veterans Diversion Program, where these things do get addressed, and also with the recovery court. So in talking with our other people in our vicinage with Atlantic County, they have had a program that was not developed as part of that original AOC program or pilot program. They developed it on their own with the courts. And it was essentially, from what I understand of the program, it was just people trying to figure out a way to develop a program that would address a need.
And it did address a very good need, I will say. And Lansing County was very good about identifying people that would fit into that program. But before what you're going to talk about occurred, the missing element was really having individuals being able to be diagnosed. It was my client's obligations to be able to have an official diagnosis and evaluation, which became difficult for my clients who might be indigent. And I, even though I'm a private attorney and my clients pay me, I will say that a lot of my clients still are struggling financially. And so if they don't have health care or the ability to get the diagnosis, they would still have been precluded from that program.
Yes. And I think there were a lot of things that people learned. And one of the problems with that program, or one of the difficulties that they were experiencing, is that there really was no funding for that program. They first got it up and running. But during the course of that, the evolution of that program, the court, because we're a joint vicinage, felt very strongly that we needed it in Cape May. And we felt
So
that
I'm
we
going
needed
to
it in Cape
interrupt
May.
you just for a second, because when people hear vicinage, I know nobody understands what we're saying.
Yeah.
So for all my family that listens, because they might be the only non-lawyers, Atlantic and Cape May County is the one vicinage, which means our judges can go back and forth. We have one assignment judge for both counties, and our counties are considered one in many ways with regards to the courts. Sorry. So our vicinage had something different in Atlantic County because we did have mental health diversionary program that was started, but it hadn't been started in Cape May. Is that fair?
That's fair. And because of the success of the program up in Atlantic County, and the judge who was handling it is still handling it, felt very strongly that this was something that could translate into Cape May County. And we did too. My prosecutors about with the Arrive program and the CIT training and things along those lines. He's very much in favor of this kind of program and these situations. But because of those, I suggested that maybe we might develop our own program. So I guess it almost was maybe year and a half ago. I was going up to view Atlantic County and see how things were going with the effort to try and start a program down here. And the courts were very supportive of that. But of course, we had no funding source, and that was a big issue. And then all of a sudden, this grant became available. And this grant is from the Attorney General's office, from DCJ. It is not from the AOC. And the grant is for a prosecutor-run program that is a mental health diversion program intended to divert people with mental health issues away from the criminal justice system and more towards treatment. It is not a blanket open-ended program. I mean, there are certain requirements that have to get met for this. You have to actually have charges. And we don't just take someone who has a VOP on an existing charge for failure to appear at a treatment or something like that. They have to have new charges in Cape May County to be eligible for our program. They really should be a Cape May County resident. though if it's someone from Atlantic County, we might be able to work something out, or someone from another county that has a program. Those are factors we have to think about. People from out of state right now, we really aren't, for the first person in the state, I'm not going to start going down that path right now. It's not to say never, but I think it's a very difficult step to take when you're trying to build something, to suddenly jump into a very difficult monitoring, if you will, program or case management program when someone's out of state. But that's why this started. This started because the court was very enthusiastic about it. We were enthusiastic about it. And then all of a sudden, this grant funding opportunity opened up. And as a result of the funding opportunity, together with Atlantic County, we applied for the grant funding and received one of the largest grants that I think probably the largest grant that they offered. And we got $1.3 million for 2 years for both Cape and Atlantic County's programs. Then we went out to bid, and we selected, and JFS was selected as the provider. So we are now in the process of reviewing applications, got court days set up, and we are going to go through and I'm screening applications. Literally, I have a couple of in front of me now that I'm taking a look at to determine if these people are legally eligible for the program. If they are not legally eligible, they're not going to get into the program.
So let's talk about that. The legally, I know Meg wants to ask the question. She's like on the edge of her feet.
I decided I was going to let you run this interview.
Oh, you think that's good. I knew you wanted to, but here's the thing is that we are all, even the criminal defense attorney here, are all in agreement that there's an understanding that there's people that can participate in these programs successfully. So I really have two questions on the legally eligible. So you said it's a prosecutor program. So what does that mean? And then the legally eligible, how is that defined? And so that people, not all cases that there might be a mental health component are going to fall within mental health diversion. And I will make it really clear and easy. If you're charged with a homicide, the mental health diversion is not an appropriate program for you. So you're not going to be legally eligible. And I don't know what other restrictions there are, but I'm 100% confident on that one.
That's a good bet. I'll tell you, I guess the first thing I should explain is that as a prosecutor-run program, our office is the gatekeeper, essentially. We're the people who determine whether or not someone can get into the program. There isn't a right to the program. This is not PTI. This is not the Veterans Diversion Program, and this is definitely not Recovery Court. So it's somewhat of a newer animal, a little hybrid of everything, but it's very clear that our office makes the determination if someone can get in, whether or not they have a mental health issue. It could be legitimate. They could have some mental health issues, but there are a couple things that have to happen. One, there has to be a nexus between the charges and the mental health. Okay, the mental health issue that's in there. The other thing that has to be involved in this. Sorry, my phone's ringing. I hope. Okay, we'll just. Oh well.
I was going to say it's okay. You're still working. It's fine.
But there are certain charges that are not going to be allowed, as you hit on it. But with the first degree charges are not going to be allowed because this is a diversion program, we can't take very serious charges. We're trying to divert them away. The ultimate end goal of this would be to have the charges either dismissed or reduced. Mm-hmm. But largely dismissed if it gets to that point. So you can't really do that when you've got a homicide. The safety of the community is such a huge issue here. And if someone is violent, I have very strong opinions about whether or not that person can get in. Now, obviously, there's going to be some situations where a person, that there are going to be grayer areas, but they're very clear ones with first-degree crimes. If there's a DV offense, and I'm talking a standard DV offense, spousal, boyfriend, girlfriend, that kind of DV offense with that kind of violence, I don't know that person will get in because of the violence and because it's a DV. Crimes against children will not. I'm going to exclude crimes against children. Sexually based offenses are probably not going to get you in. So there's a question of just safety in general that kind of covers all of this. Now, there are some second-degree charges that might get someone in, but when it comes to violent crimes or any of the ones I just mentioned, I think that those are pretty clearly not going to be covered or might be subject to a real scrutiny, even if there is an obvious need. And we do and will be taking in, reaching out to victims if that is appropriate under the circumstances, or the person who's applied has issues with the victim. I think that's a very important thing, whether that person feels safe with someone going through a mental health program, because they're not going to be in custody. They're going to have to deal with getting to appointments. They're going to have to deal with going to treatments. And it's going to be very difficult to deal with that if someone does not feel safe because the person is out there.
Right. And so I'm going to assume, with all the lists that you just gave, other than most first degree charges, that there could be unique situations depending on victim's perspective, the allegations, whether there's significant documentation, and whether the person has the support system to be in the program. But that would be up to the defense attorney to really present all of that to the state.
Yes.
Right up front, and in order to support that, or justify that.
Yes. One of the things you did mention, Melissa, and that is in terms of screening and things like that, and that some people don't have that accessibility, or there could be undiagnosed mental health issues, but everyone kind of has a feeling that there's something else going on. That's one of the things that the funding that we got is enabling us to do, which hadn't been done in Atlantic County because they didn't have that. So I think they had it done, but it's difficult when you don't have an initial screening and you just have to go on someone is acting strangely. Here, when we get an application and if someone gets enrolled or we need more information, the more information we can get from a defense attorney about anything, if they have an existing treatment provider, or if they have any medical records or any records of any kind that would show us some kind of diagnosis, if that's available, that's going to make reviewing an application even faster. But we also have JFS able to do some general screening that could tell me, okay, this person does seem to have these kind of issues. But the other thing that's really important is there's got to be a nexus. I have to have something that says that the mental health issue is what resulted in the criminal activity, or caused the criminal activity, or is tied to that criminal activity. It can't just be a run-of-the-mill thing that I have some issues and I just decided to go out and do something stupid. And that's going to be a very hard thing to prove. And I'm not saying it's going to be, some cases it will be easy, other cases it's not going to be easy at all. But the more information that we have in making that evaluation when it comes to the nexus, and that is part of the legal eligibility part, because that's clear, that's actually part of the statute. There has to be some kind of nexus. The more information we have, the better we can make that determination.
So, Meg, as you're listening to all of this, as a former prosecutor and a former criminal defense attorney, what is going through your mind when you're hearing, sort of what makes someone legally eligible, and the process of even applying or being considered for the mental health diversionary court?
Yeah, I mean, I have a lot of questions. I commend the Cape May County Prosecutor's Office for pursuing this grant along with Atlantic County, because it is so, necessary. I guess the questions that I have are, first, procedural, and that is, are you screening pre-indictment for individuals, and are they thereafter going to be expected to plead to an accusation? That would be one question I would have. The other thing that keeps running through my head is how I think this is ultimately so necessary on the municipal court level, because having practiced in municipal court as a defense attorney, I saw a number of individuals that could have benefited. And so then my next question in my mind is, would this be something that, instead of remanding a case, the prosecutor could consider resolving it up in Superior Court? And so there's some procedural questions that I have. And in terms of just substantive thoughts, it is tricky because all the parties have to be on the same page. The prosecutor, the defense attorney, and the individual charged, who half the battle sometimes is
Having them
having an
acknowledge.
acknowledgement, right?
Uh-huh.
I know I've had a number of cases when I was a prosecutor where we would want to condition a plea upon an individual completing mental health treatment. And I had a number of conversations with defense attorneys at that point in time, like, can you force someone to take their medication, for example? So the person charged has to be on the same page. And then perhaps most importantly, if there's a victim of the crime, you're going to have to get their buy-in on this too. And lots of times with these types of cases, you're going to have law enforcement officers who perhaps have been assaulted, maybe not injured, but assaulted, which rises to the level of an aggravated assault. And so there's a lot, I would imagine, your task is daunting to try to coordinate all those pieces. And there are a lot of pieces to the puzzle. So then ultimately, I guess my question would be, what is the recommended disposition? How does that work? So I think it's a wonderful program. I'm excited to hear about it. I have a lot of questions about it.
I'm going to jump in on the municipal court, Gretchen, and then
Mhm.
I'm going to like send you the ball after that. So in Atlantic County, Central Municipal Court, which has a majority of the court, as well as Atlantic City Joint Municipal Court, JFS is involved in both of them already to assist with mental health services in those courtrooms as well. It is not a mental health diversionary program there by any means, but they do have the support system in order to provide services. And there has been discussions of if there's service involved, that cases can be put on hold for a short period of time. And if they are able to, follow through with the services that they need and with no further interaction with the justice system, can have favorable results.
Yeah, and I do recall when I was a defense attorney having cases where JFS was involved, and that was a great opportunity for individuals with those needs.
So, Gretchen, I can't answer any of the other questions Megan asked. She asked about
Well-
8 altogether, so I'm just going to defer to you now.
Well, I was writing some of them down, so I got some of it. I guess one thing I will start with is that this is truly only for indictable matters. Now, it doesn't mean something can't get remanded or dealt with in that respect, but it is only you have to have indictable charges. Don't know whether this might at someday filter down to the municipal courts, but at this point, it is just with us. In terms of, I guess, the first question, I think I'll start with how this comes about, how a case gets put in front of us. And there is an application. It's on our website. You can link it in there, and the application needs to get filled out completely, I might add. I've seen some that have not come in completely, and it's difficult, but they need to be complete, and they can get uploaded through eCourts, or they can get emailed to Krista Trulender. And I believe I have her address is listed in a press release we did. Krista Trulander's with the courts, and she will schedule, once we get the applications filed to us, she will schedule that or put it on our list for staffing. The other way a application can be presented is it can be handed up in court, in which case the court staff would then make sure that we know about it, and it would get scheduled for staffing. Once the applications are in, I start to do a review for the legal eligibility to determine if this person can actually get into the court. I like to do it as soon as possible, but it does depend on the amount of information that we have given to us and what's available. There's some I can screen in and out right away. There's some that I just don't have enough information based on the application to make a full decision. And in those cases, I might reach out to JFS to do an evaluation if the person is detained or something along those lines.
And Gretchen,
We're
just
really,
so I'm
really
clear,
still in our infancy. So it's kind of, I'm trying to figure things out as we go along.
the applications,
we
though,
do-
are uploaded by the defense attorneys, right? That's
Yes,
who's
yes. Individual
it's not an
defendants aren't going to
individual
have that
defendant.
ability.
Yeah.
But that's why
It's
they could
their
also
turn.
email it to Krista Trulender or hand it up in court if that's the case. But so far, all the ones I've received have been from defense attorneys, and they've been uploaded into eCourts. we screen at any time. They can do it pre-indictment. They could do it post-indictment. I've seen some where I think that, I don't know if they sentenced yet, but I know people have inquired about that. But at this point, it can be at any time during the process. So, and we will take a look and we will consider it. It's almost like a recovery court in a lot of respects in that way, because they can file it at almost any time. But if it's pre-indictment, I don't imagine that we would have someone plead to an accusation, but I think it's going to depend on the charges. It's going to depend on maybe a criminal history or something like that. If this is a repeat offender multiple times of the same type of thing over and over again, I'm not sure we're going to just let this one slide if we let them in. So there has to be some kind of, I don't want to call it a hammer, if you will, but something there. And their options is to pleading and going through the process and having an alternate sentence as well. But these are all things that I haven't dealt with yet. I know that they've been dealt with in Atlantic, and I draw on conversations with them about where cases fit in. But at this point, I haven't experienced it. So it's still kind of fuzzy. Another thing that has come up in a lot of questions that I've had is, I've had questions from people saying, well, my client's been declared incompetent. Sorry, everything's done. There's nothing going on. The three of us all understand that, but there are a lot of other people out there who are not. We've gotten phone calls, which I can't take for obvious reasons, but from families of defendants who've been declared incompetent. No, that's not what this program is for.
Right.
So and there's a fine line between competency and this kind of program and mental health issues. And I understand that, but the bottom line is we cannot have someone in this program who doesn't understand what the program is, doesn't understand how important compliance is, and doesn't understand what the steps are that are necessary to get through. And if that's not to say that someone who is involved in the program and doesn't comply a couple times might not get second chances. I don't think that's the case. Obviously, it's very fact specific, but the individual, the defendant, because they will be charged at that point, the defendant has to understand what the program is and has to understand that compliance is important and has to understand that they have to follow through with the treatment. If that doesn't happen, they're going to ultimately be put out of the program.
Right. And that's why, I mean, you said it very clearly, Gretchen, when you said if they're not competent, they can't participate. And we all nodded. And it's clear, because if you're not competent, you're not aware. You're saying you don't understand what's going on in the courtroom. You don't understand the ramifications. You don't understand. You can't voluntarily participate in something that you cannot comprehend. I mean, so there's multiple reasons if you are not competent. And there's a whole different avenue of handling a criminal matter when a defendant is not competent. Would you agree with that, Megan?
Well, absolutely. I mean, and this is something that when I teach the course that I'm teaching, you've got on different extremes, right? You've got competency issues, in which case the case is basically put on hold until that person regains competency. And then you've got, if they can, then you've got the other end of the spectrum, as we know, which is perhaps a resolution of not guilty by reason of insanity. And then you've got this sea of cases in between, and again, the mental health diagnosis, I would imagine, doesn't excuse or justify the behavior. This program, as I'm hearing it, Gretchen, and correct me if I'm wrong, is a program that's designed to take it into consideration in the ultimate disposition of the case and what's best to not only reduce recidivism for that particular person, but also, serve justice, because that is the ultimate goal of you as the prosecutor and the prosecutor's representative, is to seek justice. So this sounds like this program is designed to do just that.
I think it is, Meg. I think the ultimate goal for someone who gets into this program would be to have their charges dismissed, provided they comply with treatment and whatever services are necessary as a result of that. But it's not a short term. I mean, I think this maybe between 1 and 3 years is the usual term. And it's does require court appearances, as many as you might see in recovery court, because you don't want to, it's difficult. But it's enough court appearances to make sure someone is staying on track, and they're going to have to work with the people who either JFS would recommend or whatever the staffing recommends. They're going to have to follow those programs. And if they follow those programs, then they can graduate, have their charges dismissed outright, or if, depending on the charges, obviously. There are certain circumstances to take into effect. But I mean, we don't want to have someone in here and have to go to jail. We want to help them. We want to help them get treatment, but they have to also want to do it themselves and help themselves. But we do take the victim's information into consideration. I will not let someone in who has violent charges, who I believe is not safe, if a victim does not want that to happen. I think that's going to be a very tough sell under the circumstances. But at this point, I haven't been faced with that, but I anticipate that that's going to be coming down the pike at some point in the future.
Can I ask a very criminal defense oriented question? It is like, I'm under the impression that it does not have to be only for first time offenders. That I understand that you might not want somebody who has, an extensive criminal record or a prior criminal record that involves violence that would be concerning to be supervised. But I'm also under the impression that the individual might or could have prior criminal contact and still be eligible for the mental health diversionary program.
Yes. And I think that under those circumstances, I think it depends on the current charges, but it also would depend on a history is going to be very important to understand. But there's certain things you're going to have to look at, maybe history, see if there's escalation, see if there's there's a lot of questions you have to ask about this. And part of that history would also, if it's available, a mental health history of that individual. So I certainly would not say that someone this is only for first time offenders. It's not.
I have one other very criminal defense oriented question, which it's so interesting. And I'm going to follow up with, I think it's so exciting for you to be on the front lines of creating a court program and having so much ability to shape the program, the dynamic of it, also the tone of it. I think that's like an amazing, I think about in my career, that would be like an amazing, I guess, accomplishment that I would be excited to be participating in. My one question with the prosecutor program, my last very criminal defense oriented question is, who gets to decide in the end if the person is in the mental health diversionary court and they're struggling? Who gets to decide if mental health diversion is terminated? Is it the prosecutor's office or is it the judge?
That's a very good question. Don't know, having not experienced anything along those lines yet, I can't really say. But I do know that multiple second chances will be given. And I think that if the determination is made, and it also kind of depends on the compliance too. I mean, if this is someone who just refuses to even attend any treatment or anything like that, or goes and commits a violent crime, I think it's going to be pretty clear what's happening.
We all agree on that.
But
there are just many things we agree on.
Yes. But there are so many gray areas here. And I think that I think that's going to be a combination of people. But I suspect that if it's gotten to the point where we're done, I don't know how that's going to play out. I have to check with my counterparts to see if they've experienced that up in Atlantic. But I think it really is a very fact-specific question. It is. I don't think it's fact specific. I wish I could.
I will say in recovery court, it becomes an issue as well. There are times that probation and those supervising really feel that the person is done, that they don't want treatment, that they're not really participating genuinely in the program, where the judge might still believe that the person can successfully complete it or vice versa. So I think that what's amazing about these diversionary programs, and then I'm going to stop because I see Meg has something to say, is that it's probably the one side of criminal practice that when somebody's involved in a diversionary program, whether it's mental health diversion or recovery court or the veterans diversionary program, that everyone who's a stakeholder, the judges, the probation, the criminal defense attorneys, and even our clients, we all want them to succeed. We're all on that same side at that point, which is, not really true in a lot of other aspects of our job.
Mm-hmm.
I'm going to let Meg ask or
Well,
jump in here because I see.
yeah, I just have, I mean, I don't envy you. I think there's going to be a lot of challenges, right? Because I haven't heard you say that second degree offenses are not prohibited from applying, but I can't personally think of a second degree offense where it would, and I'm not telling you can't do it if you want, but
I can
I
think of
can't,
some.
can't think of many second degree offenses where it would necessarily be appropriate if it wasn't appropriate for a third degree charge in any event. So then you're faced with probably primarily third and fourth degree individuals charged with third and fourth degree offenses who, for whatever reason, either don't want to use their PTI strike or are not PTI eligible, but who also, for whatever reason, we don't feel that a probationary supervision, which would generally you would consider a more strict type of supervision, is also appropriate. So I'm trying to think of, the perfect applicant and the perfect resolution and what that looks like. That's also not just better off handled as a remand. So again, I think and I don't know, and maybe you can answer this question. Does Cape May County still have a mental health caseload on the probationary side?
I think they still do. I'm not as familiar with it, but I
Right.
believe that they still have something
Right.
there.
And
I
so these individuals aren't going to be supervised by any court staff?
No, they are.
They are.
Mhm.
There's people from probation who are going to be involved in this, as well as, JFS, and the staffing meetings are going to be, we'll have people from the courts. We're going to have people from probation. There'll
So
be
it's
a
like
lot
an
of people involved.
informal probation without the
Well,
conviction for a
also,
period of time.
I can tell you
I mean,
in
there's an
Atlantic,
agreement.
in Atlantic, the probation officers that are supervising are part of that mental health
Mm-hmm.
probation unit.
Yeah.
So they
Okay.
do have probation officers. JFS isn't supervising, just so we're clear.
Yeah.
JFS is coordinating the services. They're able to
Mhm.
provide a diagnosis. They're able to provide wraparound services if individuals are having housing insecurity as well as mental health issues, if they have food insecurity, if they need more support, if they need vocational training. So they are doing the diagnosis, or they can do the diagnosis, and they can provide services, but they are not stepping in as probation, just so we're
Mhm.
clear.
Yeah. No, they that's true. That is true down here as well. And we're still trying to formulate it, but there are going to be people supervising them. It is going to be a form of probation. They are going to have to enter into an agreement, and they're going to have to keep in touch with people, or people are going to have to keep in touch with them to make sure they are doing the things that need to get done. So they're not going to be just cut loose to go follow their, go into a program. But there are people who are going to keep an eye on it. Now, it's different from Atlantic in that some of the stuff that Atlantic has dealt with, a lot of the things initially came from people going to the casinos repeatedly back and all over and over again. And there are different housing issues that we're going to experience that they don't have or have differently up in Atlantic. But I think it's going to, I'm very optimistic that it's going to play out, but I do know that there's going to be challenges. I'm already experiencing challenges looking at some of the applications because people are trying to get a feel for where we stand on issues, and they're trying to get a feel for what our program is going to mean. And, so I've seen some that I look at and I'm like, yeah, I don't think so.
Right.
This person, and another thing I want to make clear is if we get an application for a candidate and that person is should be in either recovery court, or is better served by recovery court, or better served by like the veterans program, they're going to go there. This is the last one, because from the Veterans Court for obvious reasons. There's the accessibility of the services through the VDP.
I don't know why anyone wouldn't choose Veterans Diversionary Program if they
I
had
think
it as an
yeah.
option. I think it's an amazing program in our vicinage.
Exactly. Now,
Yeah.
Someone who can't get into that program, it's another story. But Recovery Court, if you're better served, if there's nothing in there that's a clear mental health issue, then that person really doesn't necessarily belong in mental health court. So, I'm seeing challenges along those lines as to what are the boundaries of the program. And I expected that. I think we all expected that that's going to be the way it comes forward. And I think, Meg, in answer to your previous question, there are some second degrees that might qualify someone, like a second degree burglary, for example, might get someone into the program, but obviously you've got some victim input issues that you have to resolve. So it's not as black and white, but clearly crimes of violence are just something that I don't stand for. And I think that I'm not drawing a line, but they get viewed very skeptically because of the community impact of something like that.
Right.
Stranger violence is something that terrifies me as well, because
Right.
it can be so random. So I think that we're still trying to figure things out.
But
Yeah,
in the
and
second degree,
sure
I'll be quick. Some second degree charges are second degrees based on the initial, what the police hear, and that, as the cases kind of develop more, they really are third degree charges. So, so I hear what you're saying, Meg, about can't imagine second degree charges, but I'm just going to give you, and I'm not, this is not from the Cape May County perspective. This is from a criminal defense perspective, but I've had clients charged with second degree robberies where they're really shoplifting charges,
Well, that's a different discussion, what the charge should be. And
right,
whether the proofs
but
rise
these are
to the level.
individuals that are already charged. They're criminally charged. And so then the question are, what are the real facts? And this is not about Cape May, but there are a lot of cases that I have where I think the charges might be a little bit more serious than what the conduct is. And that gets parsed out. I assume that a effective criminal attorney is going to present the state with those mitigation issues and, present a packet that's saying that I know it's a second degree, but this still falls within because of these reasons. Right.
Those are all factors that we consider. And that's part of it. I mean, there is a recognition that some things, what they appear is not actually what happened. And there are various levels of that type of charge. So I think that it's just, there are certain charges, certain second degrees. Second degrees are going to get viewed a little more differently than thirds and fourths because they usually involve violence. Whereas, a third and fourth is not usually that way, but we don't rule them out completely. So it's just a matter of what is presented. There's not going to be like a hearing where you get to present to the court what your charges are. It's the information that comes to us that we take a look at and we make a decision. Is this person eligible for it? And the key things are, if you can get me information about existing mental health issues, which don't always exist, and I understand that, and that's why we have JFS do screening too. If you can get me information about that, information about a nexus, and the more information I have when reviewing an application, the better chances of making a fully informed decision are going to be. It's just, and we're going to learn as we go along. That's just the way it is in its infancy. We're trying to figure everything out. And I'm going to be I'm sure I'll be back up in Atlantic, but I'm also going to be trying to go to other counties, to their courts, to see how they handle issues like this and to see how they handle, what kind of things I can envision coming down. And they may have issues that we see in Cape May County, but Atlantic doesn't see. So I'm trying to get as well-rounded an education concerning these programs statewide so that we can really do as good a job as we possibly can in the time frame we have allotted, at least with this particular grant.
Is a plea required?
Not necessarily. Ordinarily, I would say no, but it does depend on the charges, depends on a lot of other factors. As I said, there are some situations where someone could have come into it with a plea and an alternate sentence and then you go through this and maybe things get dismissed or downgraded or something like that. So I think a lot of it depends on the charges that we're dealing with. As I said, sometimes you just need to have that extra protection, even if it's to make a victim happy,
Yeah.
Right. Well, it also provides some resolution to the case.
Exactly.
Right? And with a waiver of appeal, then
Mm-hmm.
it's there.
Yep.
So, ladies, I know we've been on for a while, but I really have just a few more questions. I'm not sure who this is better for, but how important do you think formal legal education is on mental health at this point? Where do you think we should be as lawyers regarding education as we're kind of heading down this road? And it's not just in combination. I mean, there's now a mental health court, a mental health diversionary court we're dealing with. What do you think whether the legal education system, law schools, CLEs, what should we be doing more for lawyers to kind of understand this connection?
I personally think that there should be, and I think that just the very existence of this program in Cape May County and in other counties shows an awareness on the part of prosecutors, and the training that Gretchen talked about with police shows an awareness among the law enforcement community.
Mm-hmm.
And that's a big thing that I'm teaching in the course that I have right now. So I think it's absolutely important. The knowledge and education is never for naught. So I would suggest, and I would defer to Gretchen, but I would suggest that it's very important to at least understand all the intricacies, right? We aren't mental health professionals, but if we're going to be handling and looking or teaching this, we certainly need to know as much as we can.
I would agree with that. I think that's reflected in the CIT training that I was mentioning before. That's crisis intervention training for those who aren't familiar with all of our acronyms. And I think that's a terrific program. And it's, I've taught parts of some things for it. I've also been to parts of it. I haven't been to the whole thing, but from what I understand, it's really intended to at least educate police officers, detectives, people on the front lines about how to recognize if a mental health issue is occurring, as opposed to just responding with training or gut reaction, so that you can realize that what's going on, as opposed to just and see what you can do to help. And I think that's a very important part. I think it's been very successful, and I'm really pleased with the program that we have in place, and that the response that it's gotten, and that the people who have been involved in it. So the community awareness is out there. I know we have multiple programs. I'm not going to get into all the details, but we have a lot of programs out there that are community oriented programs that kind of assist with people with issues, but also assist with the identification of the issues. I know, for example, we just started a blue envelope program for driver's licenses. And I think that's a great program. And a lot of people don't realize that that kind of situation can arise. And I think that's all really part of how that plays in. So I think that there is an increased effort at education in the identification of issues, and then also the identification of at least knowing when you need to get other people involved to help out. So I think it's there, and I think it's definitely moving in that direction.
So, Gretchen, I'm going to ask you a big view question to finish up. What does success look for you in the mental health diversionary court system? Let's say 5 years. What do you see success?
I see success is going to be based on how many graduates we have and whether we've had people successfully go through the program. It's very measured right now because we don't have anyone in the program yet. So I can't really say. We have a 2-year window right now is what our grant covers. So if we get some good numbers of people in the program who are responding to the program, and it works out well, then the program can continue. And that's what I'd like to see. That would be my short-term success. Long-term would be to see graduates come through and, be successfully treated. I can't ever say that I would never expect to see people come back. I think that's one of the issues when you're dealing with mental health, that it is something that could come back. And treatment can be long-term, but treatment can also just be a short-term Band-Aid in some respects. So I think that, and there's so many other factors that go into it: housing security, food security, support, community support, family support, things like that all go into these kind of things. So you have to look at all of this with those kind of features in mind and realize that your success can kind of depends on how things were able to work out. So I guess getting some good numbers in our program of people who are willing to try and to do things is a great measure of our success, and would allow hopefully for the continuity of the program. And then I would love to see graduates, but that takes time and patience and practice.
Great. Thank you so much for talking to me and Meg. Meg, do you have any last words? I want to make sure you said everything you want to say.
Well, I think that I would love to hear how the program is going. So perhaps Gretchen could come back on your podcast and give an update as to how the program is developing. This kind of reminds me of years ago when Recovery Court, formerly known as Drug Court, was starting, and there were a lot of kinks to work out, and there were studies that were done after a period of time to show the reduced recidivism and all the benefits of it. So I kind of feel like Cape May County and the other counties that have started these similar either pilot programs or, in case of Atlantic, the grant programs through the Division of Criminal Justice, I feel like we're kind of watching the forefront of something new and a new way to look at criminal justice. So I'd love to hear back.
Sounds good.
Well, we'd be delighted.
I was going to say same place, same time, maybe December 6th. That'll be 12 months.
Yeah.
Thank you both for coming.
So.
Thank you both for coming and talking. I think this issue of mental health has been, I've talked about it, about lawyer wellness and lawyer well-being. It has been also really, I've seen it for my whole career, 30 years doing criminal defense, how mental health really is one of the reasons that people are involved in the criminal justice system. Alcohol, drugs, mental health. And I think that if we're looking at it from a more holistic, rehabilitative approach, that we can have a safer society and really have an effect on lowering recidivism in the criminal justice system. Thanks, ladies.
Thanks, Melissa.
One of the best ways to support Melissa and the Mighty Merp podcast is to go to our YouTube page, find the subscribe button, open the menu, and click the bell icon so you actually get alerts when we post new episodes or shorts. For any questions or interest in podcasting, go to legalpodcasting.com.